All right, appearances for the people versus Frank Mishaw Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not for you how it works. So
Yeah,
you're on fire.
Are you up, please, at the desk, representing yourself?
Judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
Toward the end of that video, Judge Martin mentioned that his next appearance would be in front of Judge Oakley. And I pointed something out at the time. Some of you may remember Judge Oakley from earlier videos on this channel. He's a judge who takes the court process very seriously, and he does not entertain arguments or behavior that have no legal basis. When people come in with unsupported claims or confusing theories, he shuts it down quickly and keeps the courtroom focused on the actual law.
If I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on, are you picking him up? That's one of the reasons I want you up here, is through the microphone here.
I'll speak loud.
Are you picking him up? Yes. Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to
I didn't swear an oath to the Constitution.
You have.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'll present myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
Well, today is the day, everyone, and this hearing is truly something to see. It's one of the most striking examples of a sovereign citizen defendant being firmly corrected by a judge who doesn't hesitate to take control of the courtroom. And believe me when I say this, you probably haven't heard a judge address these kinds of arguments with this level of clarity and force before. It's an intense exchange from start to finish, so let's jump right into it. Hamad, I honestly wish more judges operated the way Judge Oakley does. He gets straight to the point, stays focused, and doesn't waste a moment on anything that isn't relevant. If there were a dictionary entry for no nonsense, his picture would fit perfectly beside it. As this video continues, things are only going to escalate. from unusual claims to escalating exchanges, and it builds all the way to a wild finish. Stay with me, because it gets more intense with every minute.
You can stick around if you want to, but I'm not gonna obligate you to stay.
I understand, Judge. I'm definitely gonna stay.
That's fine. All right.
So, today,
You have a jurisdictional argument you wanna make?
what I served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a.
Yes or
multiple-
no?
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your
Okay,
jurisdictional
so-
argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that,
I work
Criminal
under the authority
or-
of the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is
in
not
order-
admiralty,
What
and
is it?
it's not common law.
Which
It's
one?
statutory.
Okay, so it's statutory, that is what, civil?
No,
So what is it? For the
My
record, I need to
jurisdiction
have
is
it
both
on-
civil-
I can't defend myself unless I have it on the record.
At this point, it's clear he isn't making decisions that work in his favor. Choosing to represent yourself in a criminal case is rarely a good idea, especially when you have a trained attorney standing right beside you, someone who has spent years studying and practicing the law. That kind of experience matters, and it's there to protect you. Ignoring that help and trying to handle everything alone only puts you at a disadvantage, particularly in a situation as serious as this.
Is it?
my
It's
jurisdiction.
only two.
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a
legal?
criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other, it don't say statute.
All right, then you can appeal my
Constitution.
ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes,
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
there must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
electi.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement, I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure the
bringing the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat, wow.
You're probably going to hear more than one.
Realistically, you shouldn't be trying to represent yourself if you don't understand the basics of how different areas of law work. There's a huge difference between common law, maritime law, and statutory law. And if those concepts aren't clear to you, then handling your own defense in a criminal case is only going to make things more difficult. That's exactly why attorneys train for years, so defendants don't put themselves at a disadvantage by trying to navigate complex legal systems on their own.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration, with an exception for the
So-
OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100.
Nice. Do you really understand what's happening here? Because from the outside, it looks like the judge has completely run out of patience with someone who refuses to follow the most basic courtroom rules. And the reality is simple. If he continues interrupting, refusing to listen, and refusing to sit down when instructed, he's putting himself at risk of being taken into custody. The judge isn't reacting out of frustration. He's enforcing the order and structure the courtroom requires. Ignoring that is a quick way to end up spending time in a holding cell.
That's fine. Thank you. Witness.
Your Honor, the people call Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here it
This
says,
is the probable cause hearing.
it says, it's,
All right,
it
stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting
What is your legal objection?
to not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied not?
Because
have
you
my
didn't
due
give me a
process?
valid objection.
I object.
You can't just object. You got to explain with the valid
I
objection to the
object
evidence.
that we are having a preliminary exam when I haven't had a probable cause hearing and that I did not.
They're the same thing,
It's
Mr.
still,
Michaud.
on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference, and today is a different date that says a preliminary.
Have you ever had a grilled
If it
cheese?
was different,
Have you ever had a grilled cheese?
if it was different, why would it have two separate?
Have you ever had a
columns?
grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not gonna let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to.
And I'm trying to explain it to him too, but I'm not gonna talk over him.
Right.
And I'm not gonna play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that, but you gotta be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
$100. Fair enough. And honestly, let's take a moment to appreciate judges like Judge Oakley. He has a real talent for cutting through disruptive behavior and making sure people quickly understand the consequences of their actions. Judges like him keep the courtroom focused, fair, and firmly on track, and that level of professionalism deserves recognition.
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference. And in order
There's
to
no
prepare,
preparing for a probable cause
It's-
conference.
it's-
It's a conversation.
it still takes preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, at circuit court. So if he wants to sort of move forward on that defense alone, that, you know, the waiver does not preclude him from
Not at all.
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, you know, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to—
First notice, what would you like to put me on notice about?
Well, I served the notice that I requested the criminal bonding information. I requested
Criminal
the
what?
bid bond.
Hold on.
I
What?
requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
Okay,
you said it's criminal.
listen. You can't tell me something and then just disagree with me
Well,
and think
okay.
it. Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run.
You're misunderstanding what's happening here, and it's only making things harder for yourself. If you would simply listen to what the judge is explaining, you'd realize that a probable cause conference is just a basic meeting where both sides discuss the case. It's not a hearing, and it doesn't decide anything. The probable cause hearing you're upset about is actually taking place today, which means you haven't waived anything at all. The judge has already made this clear. You're not losing any rights. And you're not being forced to give anything up. Sometimes it seems like people in situations like this need extra reminders just to stay grounded, because ignoring what's being said only creates unnecessary confusion and tension in the courtroom. Paying attention and allowing the judge to explain the process would make everything far easier, not just for the court, but for you as well.
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address, okay, so.
I'm not addressing any of that crap you
Can
got in
you-
front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great,
you have-
then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize
a
any of that.
United States citizen. I am
Stop,
actually
hold on,
identified.
stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't
Under
recognize that.
Under what law could you represent or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean, hold
prove
on. It should mean something
Can
because,
you prove it? Please prove
can I
it.
prove what?
Prove that I am not that I am the artificial person. Here
I
it
can
is.
prove you're Frank
I have
Michaud.
full faith and credit.
I can prove.
Okay, so
Hold on, you've
Are
asked
you-
me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I
You
asked
proved
you
it for
threatening
me.
You threatening me.
But if you're not you, the threat means nothing.
If his orders truly meant nothing, then why are you following them? The answer's simple. Deep down, you understand that the judge is applying the law correctly and that your objections don't have any real legal foundation. Even if you won't admit it out loud, your actions show that you know he's right and that resisting further would only make your situation worse. Sometimes compliance reveals the truth more clearly than anything said in the courtroom.
But
Okay.
you're still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
Listen
you
to
have,
me. Mr.
you
Michaud.
have, you have
I've
multiple
wasted
officers.
too much time with you. Yes or
Okay.
no?
So,
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
We've reached the point where this person's beliefs and actual reality finally collide. On one side, you have the ideas he's convinced himself are true. Ideas that might sound comforting but have no real grounding in the law. On the other side, you have the real legal system, which operates on facts, evidence, and established procedure. And when those two forces meet, reality always comes out on top. Especially in cases involving sovereign citizen arguments. This brings us close to the end of the video, but before wrapping up, the judge shared a few additional comments that are worth paying attention to. His closing remarks add even more clarity to why this situation unfolded the way it did, and why the outcome was never going to go any other direction.
That's why circuit court judges have jobs.
Definitely.
Take him out of here.
Under color of law.
I can give you more than 30 days. John, ask the wife to come in so he can see his property go to his wife. Ma'am, would you accept some personal property from your husband, please?
That was an extreme amount of patience.
Good try.
I appreciate you, giving him as much latitude as you did.
I just can't let him run things. I'll let him engage me and, I don't mind that, but I just can't let him try to run things.
Yeah. No,
Especially when I got 3 or 4 more exams to do.
right.
The internet is the worst thing in the world for these guys.
I tried to tell him,
It don't play here.
the court is going to deny your objection, let's allow this to move forward. He might have been able to like win this.
And that's the
case.
worst part about all these
Yeah.
cases, right?
Yeah.
Because sometimes they've got a chance if they just,
We had a good
Ron White,
argument.
right?
Yeah.
Got a constitutional right to remain silent, just can't do it.
You can't fix stupid.
All right, everyone, this really is the end of the video. But don't worry, there's plenty more ahead. Because of his disruptive behavior in court today, he wasn't able to finish his probable cause hearing. That means we'll be getting at least one more appearance in front of Judge Oakley, and likely additional hearings when his case reaches the circuit court judge. So yes, there is definitely more to come. If you enjoyed the video, feel free to hit the like button. If not, the dislike button is there as well. Don't forget to share your thoughts in the comments and subscribe with notifications turned on so you don't miss any upcoming content.